Hello, beautiful people. Mic check, mic check. They changed some things. How's everybody doing today? Shout out to everybody who's watching. Hit that like button. I see we're starting off well populated. It's good to see all of you beautiful people. Thank you very much. Hello, beautiful. I love this name. Kicks and Crowns. K Sharp getting us kicked off. You've been killing it lately with these updates. I try. T. Coleman, how you doing? Here you are. You're in here. We made it. Good to see everybody. Hit the like button. Shout out to all of the members and subscribers here on YouTube, all the members on Patreon, all the supporters on the sub stack. There's a new article up today called Stop Judging Drake. Read it. If you feel reactionary, take 10 deep breaths and read it again. Okay? If you're quick to comment because you think you have a snappy comeback, take a walk. Read it again. Think about it. Okay? All right. I think it's worth your time. And also, it's not a debate. Okay? So just know that. It can be a conversation, but it is not a debate. We don't do that here. So, today, on the saga, we have a nice little surprise. We have the we have a transcript. I'm sorry, I'm looking at the comments. Y'all are moving. We have a transcript of the oral arguments for the motion to dismiss. That's not it. And obviously, I'm going to read it myself. So I might as well read it to you too. Right? Right. That's why we're here. There was a lot of misinterpretation about the oral arguments for motion to dismiss, and a lot of reductive pancaking, oversimplification of what happened, what was and wasn't argued, what the judge didn't say. And those hot takes were by people, who will come to mind when you read today's article, which is available to you on the post tab. And maybe a mod will drop the direct link. That would be helpful as well. So since I'm not going to count on anybody else to tell me what is in this document, obviously, I'm going to be reading it myself. And this is our first transcript. This is our first little transcript. We got a nice little celebration here. We have our first transcript because we are here to honor the one and only.
I study rap battles for a living.
I don't care, and I'm not going to give that a disproportionate amount of credit to what else exists. It's where you put your gaze. It's where you put your focus. It's where you put your brain. So, is it a reality? Sure. Is it a barrier? Yeah. Is it becoming an excuse? Definitely. Is that unacceptable? Absolutely. I know it wasn't a dig. I didn't take it as a dig. I'm just giving it healthy and appropriate pushback, not you. It. There's a difference. Get that thumb in motion. Mods are here doing the damn thing. Well, I do. I study one now. Shout out to everybody who's watching. Okay, so yeah, it's a transcript. It's 53 pages. This hearing happened on June 30th, I believe, and obviously we are, matter of fact, let me do something before I share my screen. We are waiting for the ruling from the judge. Anybody who's out there saying they know what the ruling is going to be doesn't know what they're talking about if they're not the judge. So don't let them okie dokie you into some BS nonsense. It's not helpful to you and it's not helpful to the culture. Okay, put that in place. Put that back up in place. Look at that. Perfect timing. Okay. Noted. FICO the Fly is still here. If anybody's wondering, FICO the Fly is still here. I know you're not wondering. Yep, this is our first transcript. I feel pretty confident in saying I don't believe we've had another transcript. So we're going to start with is on my last fucking nerve. Thank you, beautiful. I appreciate you. Oh, for people who are wondering about the thumbnail, I can't take any credit for that. That image comes from Drake's lawsuit. Remember that? Remember that for those of you who were here the day that we read his lawsuit and we were scrolling and the images started to come through? So that's what that's from. It's from Drake's original lawsuit against UMG. That's what that image is from. I did not do that. I just took a screenshot, shared it with y'all good people. Okay? So if you're wondering what's going on, we reading a transcript. Well, I am. I'm not going to do voices, okay? I might get tempted to, but I'm not going to do voices. The court. Good afternoon, everyone. We are here today to hear oral arguments on defendant UMG Recording's motion to dismiss the complaint filed by Aubrey Graham, popularly known as Drake. So let me outline how I'd like to proceed this afternoon. Since this is UMG's motion, they're going to argue first, and then I'll hear from plaintiff's counsel, and then I'll allow UMG to have a rebuttal. For the sake of the court reporter, I would appreciate if counsel would speak at the podium today. I do want to let everyone know that I have received the amended complaint, the documents that were the subject of the request for judicial notice, and the parties' memorandum of law. So you should assume in your arguments my familiarity with those materials and the arguments of the parties. To preview you my specific concerns and what would be most helpful for the court for you to focus on, there are a few issues that I would predominantly like to hear from counsel today. The first of those is whether or not I can make a legal determination at this stage in the proceedings as to whether or not the statements challenged as defamatory in Kendrick Lamar's lyrics are fact or opinion. I referenced this in today's article. I've done a video about it. If you actually want to understand what the judge can and cannot do in dismissing a case, then you need to understand the difference between a matter of fact and a matter of law. I'm not going to break it down for you now because I've already broken it down on this channel. I'm bringing it up to remind the folks who have seen it or who are familiar with this detail that that is what she's saying. She's not saying legal carte blanche, not legal general. She's not saying that generally. She's saying as a matter of law, because that's the only thing that she has purview over, is a matter of law. So when she says the first of those is whether or not I can make a legal determination, she's referencing matter of law. Okay? Second, if it is appropriate for me to resolve that on a motion to dismiss, whether and to what extent I should consider the documents submitted by defendants in their request for judicial notice in making that determination. Now I need to find something. UMG submitted a request for judicial notice, which is not the same as the things that were attached to the lawsuit. A request for judicial notice is a specific action that the attorneys are taking to say there is other information that the court should be on notice exists and should take under consideration along with our motion to dismiss and the exhibits we have attached to our motion to dismiss. There is context that the court needs to take into consideration. And because this is a matter of defamation, context legally applies. And so what UMG has argued that the court needs to take into account as context for their motion to dismiss and everything that has happened. Context for their motion to dismiss and also context for Drake's lawsuit, because Drake doesn't give the context as we lived it and experienced it in his lawsuit. He has a different narrative. He has a specifically carved narrative, and it does not include everything that we lived and experienced, right? And so UMG made a very strong effort to inject that context of where did Not Like Us even come from? Why did it even come into existence? Drake gives no context of that in his lawsuit. He just woke up one day and was on the receiving end of an attack. That's basically how it starts. And then people are shooting at his house, trying to kill him. So I know you can't see this, but just so that you are aware, the notice for judicial request is on the docket, and these are all of the things that the court said you need to take these things under consideration for the context of Drake's lawsuit and our motion to dismiss. Exhibit A, Protect Black Art petition. This is the petition that Drake signed saying lyrics should not be used in court. Exhibit B, back to back. Exhibit C, W Freestyle. Exhibit D, first person shooter. Exhibit E, like that. Exhibit F, push-ups. Exhibit G, tailor-made freestyle. Exhibit H, Euphoria. Exhibit I, 616 in LA. Exhibit J, Family Matters. Exhibit K, Meet the Grams. Exhibit L, The Heart Part 6. Exhibit M, Grammys List. Exhibit N, USA Today. Exhibit O, Fox News. Exhibit P, The Guardian. Exhibit Q, The New York Post. Exhibit R, People. Exhibit S, Complex. Exhibit T, NPR. Exhibit U, Toronto Sun. Exhibit V, GQ. Exhibit W, The New Yorker. Exhibit X, The New York Times. Exhibit Y, an affirmation, which is a statement. Exhibit Z, mob ties. So, in oral arguments, what the judge is saying, is it appropriate for me to resolve that on a motion to dismiss, whether and to what extent I should consider the documents submitted by defendants in their request for judicial notice in making that determination? So she's saying, can I consider these things? Argue amongst yourselves in front of me, right? Make your arguments to me. UMG's obviously going to argue, yes. And here's all the case law to back up why you should consider these things. Drake's lawyers are obviously going to argue, no, you should not consider these things. They're not relevant at this stage in the game. They should not be considered on a motion to dismiss. This context at this stage is irrelevant. There's going to be a lot of reference to case law, okay? And we're not going to look up any of them. And I'm pretty sure that there's only one in here, maybe two, actually, that I could speak honestly and say that I have some reference of knowledge of. I don't play like I know when I don't know. Okay, so here we go, diving right back in. Finally, applying the New York Steinhilber factors, case law, are the challenged statements fact or opinion within the meaning of New York defamation law and the New York State Constitution? With that preview of the court's particular concerns, counsel, you may proceed. Mr. Ransom, this is UMG's attorney. Thank you very much, Your Honor. And thank you for the guidance, which is helpful. I will focus my comments on Drake's defamation claim, although I would like to address the other two claims as well. And I'll focus on our primary argument, which is also the subject of the court's questions, which is that the statements at issue constitute non-actionable opinion rather than statements of fact. And to frame it, including in light of the court's questions, I want to start with a critical observation, which is that under binding New York law, that issue, the facts versus opinion issue, is a question of law solely for the court. It is solely for the court to decide as an issue of law, which we believe makes it particularly suitable for a determination on a motion to dismiss. And we see, and I will address, a number of cases dismissing claims on this basis. And it is amazing to me that not once in Drake's 27-page brief does Drake acknowledge that this is, in fact, an issue of law for the court rather than a factual issue, matter of fact, matter of law, to be determined by a jury, the court. Well, let me stop you there, because you are correct that there are a number of cases where courts have decided this on a motion to dismiss. The New York Court of Appeals in Bryan is one such case, but then subsequently, following Bryan, New York Court of Appeals had Davis versus Boheim, which is in the context of a motion to dismiss and relied quite heavily on the early procedural posture of that case in finding or holding that the standard that applied at a motion to dismiss stage was whether or not the communications, taken in their ordinary meaning and context, are susceptible to a defamatory connotation, and suggested that if they were, and that if they could be taken in such light, then the motion to dismiss should not be granted and discovery should proceed, which strikes me as being somewhat in tension with the court's prior decision in Bryan, which, as you have observed in your brief, did permit a motion to dismiss because it is an objective standard. It's a reasonable listener standard, a question of law, and applied a somewhat different articulation of the test as to would the reasonable listener have understood the allegedly defamatory comment as opinion versus fact. What does that mean? What this means is previously there was case law where the court had determined at the stage of motion to dismiss that a case could be dismissed. I'm just going to keep it real simple for you, okay? And then that went on appeal. And the Court of Appeals said, actually, wait, no, we disagree. That's the simplest that you need to know. They gave a reason, and that's what she's saying. She's saying, okay, on this case, which you argue very well, yep, I agree. I'm sorry. I agree, all of those things. But then it went to the Court of Appeals. And the Court of Appeals kind of looked at it a different way, came up with different language, and said this case should not have been dismissed. And then, the case procedurally went forward from there. So what about that? That's what this section is focusing on. And then again, this is the court. I would like you to address that tension between those two cases. How do I reconcile them when I have to apply New York law? Mr. Ransom, of course, Your Honor. Two things about Davis versus Boheim. The first, including the way the court characterized it, the issue of whether a particular statement is susceptible to a defamatory connotation is a distinct element of the defamation claim from the question of whether it is fact or opinion. And I recognize that on that issue, whether a statement is susceptible to a defamatory connotation, there are cases that suggest that where there's a dispute as to whether statements could have a defamatory connotation or not, might go to the jury. That is treated distinctly from fact versus opinion. And in fact, we see that distinction in Goldfarb, the case that Drake primarily relies upon, in which, as we pointed out in our reply, they misapprehend on this point because the court considers separately and distinctly the question of defamatory connotation on the one hand and fact versus opinion on the other. And as to fact versus opinion, the court expressly notes that that is a pure question of law. The second observation, the court, that is true, but I do want to press back on your reading of Davis, because Davis also does consider the opinion versus fact distinction and says that they cannot state as a matter of law that the statements are pure opinion because there's a reasonable view of the claims that have been asserted in the complaint. And that the court has to take that reasonable view in favor of the plaintiffs at the motion to dismiss stage, and therefore decides not to dismiss it. So, although yes, they also discuss the defamatory context, there is a portion of that opinion that is focused on the opinion versus fact distinction, which is the one raised by the defendants in this motion. Mr. Ransom, and I do think in that respect, there's a slight conflation, even in Davis. That said, Davis continues to apply the Stein-Hilber test, including the consideration of the four, sometimes collapsed as three elements of determining fact versus opinion. And I think what's ultimately critical about Davis gets to the court's final question of those that it laid out, which is this fact versus opinion? And what was critical in Davis was the court's ultimate conclusion that the nature of the statement in Davis strongly suggested that the speaker had undisclosed information underlying his statements that would lead a person to conclude that they were statements of fact. And yeah, I am going to skim because again, this is 53 pages. But that gives you a good idea of where they're starting and how finite and singular and pointed and specific they are with language in defining what it is that has to be decided how what has to be decided is defined and who gets to make the decision, the court or the jury. Okay, I'm going to skip. Okay. Epithets, fiery rhetoric. This is the attorney. Epithets, fiery rhetoric, or hyperbole. It might as well have said statements in a rap battle. And even Steinhilber and the subsequent cases, including Davis, as exemplified in Davis, recognize that contextual assessment of the context in which the statements are made often ultimately determines whether one would perceive these as fact versus opinion. And that's what was found in Davis, because of the context in which those statements were made. And on the other hand, in Steinhilber, because of the context the statements were made in Steinhilber, the court affirmed a motion to dismiss, dismissing the complaint as a matter of law, concluding that as a sorry. The court affirmed a motion to dismiss, dismissing the complaint as a matter of law, concluding that although the statements may be perceived as factual, the context in which they were made would lead a reasonable observer to conclude that they were pure opinion, including because of the heated nature of the communication. The court: since you bring up context, isn't the logical import of your argument that statements made in either a rap battle or diss track, therefore, are categorically opinion? Isn't that the logical conclusion of what you are saying? And is that a fair reading of New York case law where the New York courts have said forum is not necessarily dispositive, relevant? But it does seem to me that you are arguing that forum here is dispositive. A rap diss track just can't be taken as fact. Mr. Ransom: Your Honor, the cases that say forum is not dispositive, I don't dispute that proposition as a general proposition. It's typically raised in the context, for example, of an op-ed page or letter to the editor, where the context would tend to suggest one of opinion, but the courts say it's not dispositive. And I suppose in those circumstances that it's theoretically possible that the nature of the communication, even in what is otherwise thought to be an advocacy piece with heated rhetoric, may support a finding of fact versus opinion. Whether a diss track in a rap battle could ever cross the line from opinion into fact is an interesting question. I would submit that the nature of the art is that is at most highly unlikely and may categorically be the case that it doesn't. But what we're dealing with are the facts in the case here. And what we can see and what we can look at on the facts here is that the nature of the lyrics clearly convey the sort of rhetorical hyperbole, over the top, trash talking extremists that, using the language of the Court of Appeal in New York and the federal courts applying it here in the Southern District of New York, are clear, and we submit dispositive indicia of rhetorical hyperbole and opinion rather than fact. And you can see that more pointedly in cases that are closer to this than those that offer the reservation about the forum in which the statement is made. So, in Hobbs v. Imus, for example, again, affirming the grant of a motion to dismiss, the court relies on the fact that these are shock jocks, and it's not just the limited statement in which the alleged defamatory communications are made. The court relies upon their notorious history and the nature of shock jock journalism from these speakers in particular as supporting its conclusion on a motion to dismiss that the context tells you that these are statements of opinion. And it acknowledges that if you just look at the statements taken in isolation, one could argue that they have the indicia of fact. But when you look at the shock jock context, the court ultimately concludes the claim must be dismissed. In Rappaport, judge. Again, let me press you on this. The context here is the rap diss battle, and we're here on a motion to dismiss. When I'm considering that context, don't I need to know more about whether the ordinary listener of, and maybe there's a question as to who is the ordinary listener? Is it someone who doesn't follow rap music and is just hearing it on a radio? Is it someone who's actually immersed in the community and that type of music and has that background? Those are questions that we could also discuss. But with respect to the context on your motion to dismiss, how can I say that the ordinary listener would, comparing this now to the shock jocks? Shock jocks say shocking things. How do I, sitting here as a judge, know that the ordinary listener of a rap diss track would also have that same underlying assumption? Isn't it true, for example, that sometimes accusations are made in rap battles that are true and turn out to be true? And maybe listeners have that understanding. And sitting here as a matter of law, can I say that they would not? Do I need to have more discovery, potentially experts, potentially more context for this particular rap battle or rap battles writ at large before I can make such a judgment as a matter of law? Mr. Ransom, there's no suggestion in any of the cases that this is the subject of, for example, expert testimony or otherwise. What the court is required to do under the standard, as articulated in both the New York State and federal cases, is to look at the material before it and reach that determination based on its evaluation of the statements and the surrounding context. And we can again look at an example of Terrain v. Liu. And in Terrain v. Liu, again, resolved on a motion to dismiss, the court did take into account the context. And I do want to address the court's question about whether it can look at this material at this stage, because I think Terrain, case law, is particularly probative of that point. But the court looks at the information and makes an assessment on its own. It did the same thing in Rappaport case law. Now, admittedly, Rappaport was a summary judgment motion, but it illustrates the nature of the information the court is to consider in reaching that determination, which is the language used and the broader context in which it is provided. That's the universe of the material it looks at, and then it comes to a judgment. Judge. But if the broader context, which is what we're talking about, is perhaps a specialized world, then perhaps the court does need more information that is in the four corners of the complaint and even in the request for judicial notice to understand that context and correctly apply the legal tests. Do I have enough facts about that broader context to come to a decision about what a reasonable listener would conclude, whether or not the statements made in the song are to be taken as fact or opinion? Mr. Ransom, Your Honor, again, what the cases do is look strictly at the material that's presented, including the context that's provided. You do have additional information, certainly in the form of the amicus brief that was provided in support of our motion, but also from the complaint itself. And what is interesting and notable in this case is that the complaint not only includes the allegation, but it cites and references the fact of the rap battle, articles describing the rap battle, articles describing the context of the rap battle, and the history between these particular artists, including the rumors, innuendo, and controversies that have surrounded Drake with respect to his relations with underage women for an extended period of time. The context is provided there. There's no suggestion in the case law that the court needs to limit itself to a particular type of individual, a particular type of listener, or that every listener has perfect knowledge of all the information surrounding it. That would turn an objective test into a subjective test that's dependent on individual particular listeners with very specific information. And none of the cases suggest that this is required. In fact, all of the cases that talk about this issue posit that the information is generally available and considers with that information that is available, what would the objective listener reasonably understand? And on the question of what the court may consider and evaluate again, we look at terrain in particular. Here's a case where the speaker made a statement and the plaintiff disputed whether or not the court could consider the surrounding context, including earlier statements by the plaintiff that prompted the defendant to make the challenged remarks. In footnote 1 of the circuit opinion, it's also in footnote 1 of the district court opinion. The court says, terrain, the plaintiff, contends the district court improperly considered the statements that he made during his war of words because they were not included in his complaint. That argument fails. As noted above, in determining whether a statement is actionable, the court should look to the overall context in which the assertions were made and determine on that basis whether the reasonable listener would have believed that the challenged statements were conveying facts about the libeled plaintiff. Terrain himself introduced this context in his complaint, noting that he was engaged in a war of words with a rival disc jockey. That's exactly what we have here. Drake's complaint identifies the rap beef, identifies a number of the tracks in the rap beef, and then cites countless articles describing and discussing the rap beef and all of its context. And all of that is properly before the court and may properly be considered by the court in connection with a motion to dismiss. And I think what's critical is that it includes, for example, Drake's own statement in Tailor-Made Freestyle, in which he specifically said and prompted Kendrick Lamar, referring to himself in the third person, talk about him liking young girls. That's a gift from me. So when Kendrick Lamar then raps, "Hey Drake, I hear you like him young," there's no secret or surprise or mystery of the context in which that statement is made. Again, these lyrics, this context is all properly before the court, including because of the way the complaint is pled and the abundant references not only to the lyrics themselves and the beef itself, but also to articles that provide the context to the court that allows it to make the determination that it needs to make. I can't believe I just read this shit in a court document. Hit the like button. What the fuck? Wow.
High five. I'm bulletproof.
I'm going to read it again. It was so good. I'm going to read it again because it's so good. And I think what is critical is that it includes, for example, Drake's own statement in Tailor-Made Freestyle, in which he specifically said and prompted to Kendrick Lamar, referring to himself in the third person, talk about him liking young girls. That's a gift from me. So when Kendrick Lamar then raps, "Hey Drake, I hear you like him young," there's no secret or surprise or mystery of the context in which that statement is made. Again, these lyrics, this context is all properly before the court, including because of the way the complaint is pled and the abundant references not only to the lyrics themselves and the beef itself, but also to articles that provide the context to the court that allows it to make the determination that it needs to make. So I just want to pause here and say, give a hands up or something if you now understand that this motion to dismiss is not about whether or not the judge believes Drake or believes and likes the song. This is a matter of case law. This is a matter of determining what is before and under the purview of the court as a matter of law and what is not in the purview of the court, and therefore systemically requires the case to go to the next step, which is not trial. It's the continuation of discovery and then potential other ways that a case could get thrown out or reduced. It's pretty fucking incredible. I'd like to briefly address what seems to be the primary argument that was raised by Drake, although I think not necessarily specifically raised by the court. But in the event there's a question, there is heavy reliance on online statements made after Not Like Us came out, which Drake says suggests that members of the public believed that these were statements of fact rather than opinion. And this argument is wrong for so many reasons. It misstates the standard, legal standard, okay? Because again, you don't look at the subjective view of individuals. It is an objective test based upon the reasonable listener. So it doesn't matter what 10 or 20 or 40 or 60 people say, because that just reflects subjective views. And that's even before you get to the substance of the reviews, which themselves reflect this rhetorical hyperbole, not to mention emojis and misspellings, profanity, and even racism and anti-Semitic remarks. Nothing of that informs the objective standard the court is to apply. Second, it ignores the fact that this exact same argument was raised and rejected in Rappaport directly at the district court level, where evidence was submitted of all of these statements of people after the diss track was released by Barstool challenging Rappaport. And Rappaport argued, this shows that people thought it was fact. And the court rejected that argument, and the Second Court of Appeals affirmed that. And it ignores Drake's own statement. Drake's own statement, which we've attached as Exhibit A to the request for judicial notice, about the perilous danger of relying on statements in rap tracks and rap lyrics as truth, as evidence of truth, as statements of fact, about the chilling impact on this art form and the chilling impact on artists. And I don't think that can be overlooked. Drake himself took the position that you shouldn't do exactly what he's asking you to do right now. He was right then, and he is wrong now. Finally, on defamation, Drake has also argued that this is somehow mixed opinion, suggesting that somehow Kendrick Lamar is uniquely and privately privy to undisclosed facts about Drake's sexual proclivities. I think just to say it refutes it. But again, Drake himself goaded Kendrick with talk about him liking young girls. That's a gift from me. And Kendrick says, hey, I hear you like him young, and goes from there in Not Like Us. No suggestion of some hidden secret information. But in any event, this is also an issue of law for the court judge. But there are lyrics that tend to suggest, as plaintiff points out, that there is information that Mr. Lamar is privy to. The reference to the rabbit holes and other truths that he can tell, that one potentially could read as suggesting that either his statements regarding Drake are based on undisclosed information, or that potentially there are other secrets that he has not revealed. There's some ambiguity there, but on a motion to dismiss, I have to read the ambiguity potentially in favor of Drake. Mr. Ransom, And again, the case law makes clear that this is also an issue of law for the court, and that the court is to consider context of that specific circumstance as well. We see that in Cooper v. Templeton and in Steinhilber itself, where the court says in evaluating this question of whether there is undisclosed facts, the court must consider the context. And so, for example, in Woodbridge, the court says, although some of the statements are based on undisclosed, unfavorable facts known to the writer, the disgruntled tone and anonymous posting, among other things, point to opinion, and ultimately concludes opinion rather than fact. We also see the same thing in Terrain, which, although it suggested some unknown fact, the court said, look, I look at the context as a whole, and this heated public statement tells me that, notwithstanding this trash talking, including about putative undisclosed fact, ultimately, it's opinion. So yes, when Kendrick refers to a rabbit hole, that is part of the rhetorical hyperbole throughout Not Like Us. And the court must consider that context in evaluating that as well. It's the same way when Drake threatens that Kendrick's darkest secrets are coming to light, or that Drake dug up bones in an excavation. That context is part of the nature of the rap battle, and we see that in the amicus brief as well. It does not save Drake's claim here. Judge, let me challenge you on one specific lyric from Not Like Us, and that's the certified lover boy, certified pedophiles. It does suggest particularly the use of the word certified, again, an ambiguous term, but paired as it is with certified pedophile, it could give the listener, a reasonable listener, the impression that in some way there's been some determination that in some unspecified official way that Drake is a pedophile. What is your response to that argument, Mr. Ransom? Two things about that. First is I think it's critical in considering that particular passage to pair it to what precedes it, which the court quoted certified lover boy, certified pedophiles, referring to Drake and his crew. The certified lover boy is the name of a Drake album. And so it is clearly and deliberately a play on those words. And any more than the certification of lover boy status has meaning, the reference to certified pedophile is more of the rhetorical hyperbole that we see in this precise context. It also can't judge. This does bring me back a little bit to my prior question, though, which is, who is the ordinary listener? Is it someone who's going to catch all of those references and all of these nuances between these two artists and the community writ at large, so that they're going to understand that Drake had a prior album called Certified Lover Boy, and this is a play on those words? Or is it that the ordinary listener who may not listen to either of these artists with any regularity and may not have that familiarity? Who is the ordinary listener? And how do I apply that test when there's so much specialized and nuanced to a lot of these lyrics that does require in-depth analysis to catch all of those references? Mr. Ransom. So two things, Your Honor. One, on that question, all of the cases, at least in the way they apply the law, consider the entirety of the context. They don't slice and dice it down to what a particular listener of all of the context may have known and whether every listener knows every piece. In every one of these cases, what the court looks at is the context as a whole, not sliced and diced down to individual listeners, or assuming that it's limited to just people who actually have specific knowledge of particular pieces of this. The other comment I would make with respect to the concerns regarding nuance, or will someone get that is that there is a danger to that approach Wait a minute. His words are either his words are jumbled or this is jumbled. Give me a second. Okay, let me try and vocally act this out. The other comment I would make with respect to the concerns regarding nuance or will someone get that is that there is a danger to that approach that is at least warned in Bryan v. Richardson and also in Mann v. Abel, and other New York Court of Appeals case about sifting through communications and picking particular words or phrases out and considering them in isolation. And what Bryan v. Richardson says is that is dangerous too. Because rather than sifting through a communication for the purpose of isolating and identifying assertions of fact, the court should look at the overall context in which the assertions were made and determine on that basis whether the reasonable reader would have believed that the speaker was conveying statements of fact. We see the same thing in Mann v. Abel, another New York Court of Appeals case. Although one could sift through the article and argue that false factual assertions were made by the author, viewing the context of the article as a whole as we must, it was protected opinion. And in that case also, the claim was rejected. So the notion of trying to look at a particular phrase, tease it out, and not take into account the broader context of Not Like Us as a whole. Hey, Drake, I hear you like him young. And Drake's statement, talk about him liking young girls. And then the broader context of all the rumors and innuendos and controversy surrounding Drake, young women, and girls, I believe, misses the thrust of the cases that drive the court's decision, particularly Bryan and Mann. Judge. This brings me to my second question, which is the question for judicial notice, because the rumors, innuendo, etc., are not set forth in the four corners of the complaint, except perhaps in some of the exchanges in the song lyrics. But obviously, the defendants have submitted articles that it wants the court to take judiciary notice of that allude to those rumors. And presumably, for the purpose under Rule 02, it's not necessary for the truth of those rumors, but that those rumors existed and were present in the world. Who said that months ago? Me. I did. Mr. Ransom, that is correct. It is not for the truth. It is not for the truth of the rumors. It is for the fact that their existence and the context that it provides with respect to the statements in Not Like Us. But as to whether the court can take judicial notice, the answer is, in that respect, certainly. News articles well within the scope of judicial notice, as are song lyrics. And that is particularly true here because of the articles that we're citing and are referencing come from Drake's complaint. They are referenced in, cited in, and some of them discussed in Drake's complaint. Now, not necessarily the rumors portion, but the specific articles themselves are from Drake's complaint. And we cite them just as Drake did. And in our brief, we identify, and in our request for judicial notice, we identify where from the complaint they arise. So this is not a scenario where we are going out and finding third-party material that has not already been brought into this case by Drake in his own pleading. On the contrary, when it comes to the questions of rumors and the facts giving rise to the statements that are at issue here, those are included in articles that Drake himself cites and relies upon in his complaint. So we believe the court could properly take into account news articles under the standard RJN, request for judicial notice standard, but particularly in this case, where they are referenced in the complaint and cited in the complaint and relied on by Drake, we think it's particularly appropriate that the court is well within its authority to do so. And given the requirement that the court consider context, we think, respectfully, that the court is obligated to do so because that context has actually been provided, not just by us, but by Drake in his own complaint. Judge, you said you also wanted to address the other causes of action. Let me give you a few minutes in which to do so. Thank you, Your Honor. I will be brief. We've obviously briefed our challenges, and there are many, to both the Section 349 claim and the Penal Code claim. Give me a second. Okay, so 349 is Payola, the New York business law dispute. I'm just going to skim this just so you know. We're going to stick to the meat and potatoes. And it's short. He concludes it with, so we think both the 349 and the harassment claims should be dismissed as well. Judge, thank you very much, Mr. Ransom. Mr. Ransom, thank you. Judge, I'll give you an opportunity to argue in rebuttal at the end. Let me hear now from Drake's counsel. Mr. Gottlieb, are you going to be presenting argument on behalf of the plaintiff? Mr. Gottlieb, yes, Your Honor. Okay. How we doing, chat? I'm not a machine. I'm not a robot. We're on 24:53, so I think we're doing very, very well because we're under an hour. Man, original sacred high five. Good job. We are under an hour. Yay me.
High five. I'm bulletproof.
Gotta wet my whistle. Shout out to everybody who's watching. Hit that like button. Good. Yes, it is. I feel the same way about it as I did when it happened. I'm here for y'all. I feel the same way about it as I did when it happened. The oral arguments for almost any motion are the judge appropriately. First of all, I mean, this is just standard. No, the only reason why this is remarkable is because of the subject of it, the topic. This is remarkable that we're reading this shit in a court transcript and they actually had oral arguments. Like, that is remarkable, but this is standard practice. So this is exactly what I would expect because this is exactly how it goes. They argue about interpretation of case law, what the court has the power to do at this stage and what the court doesn't have the power to do. The judge asks sometimes probing, sometimes rhetorical questions. It's a stress test of the arguments and also an opportunity for the judge to get clarity on arguments and for attorneys to give clarity on arguments that they've already submitted on paper. Remember, there's always a back and forth on paper before we get to this stage. And we've gone through every piece of paper in the back and forth that got them to this stage of arguing the motion to dismiss. So this is exactly what I would anticipate. It's unremarkable in that way. It's only remarkable because holy shit, I can't believe I'm reading this in a court transcript. Wow. We got over 1,000 of you here. We can certainly get over 1,000 likes as the live is going. Let's break some channel records because I'm working here. Okay. I'm not a robot. I'm not a machine. I'm sitting here working and sweating, reading this document in as entertaining and informative a fashion as I can for y'all, because I care. There's also a super chat goal. You could help make that happen too. Okay, so we've heard from UMG's lawyers. That was very interesting. We're going to hear from Drake's lawyers now. And then there will be a brief rebuttal at the end, as the judge said, from UMG's lawyers to whatever it is Drake's lawyers are about to say. Again, that's standard protocol. Whoever brings it gets to finish it. It's standard. I'm glad that you're enjoying yourselves. It's on the record forever. You know, some of you are like, I need that audiobook. Well, you're getting a full read. I'm really proud of myself because I did not read this beforehand. And I am tossing in inflections and, emotion. I am into it, quite frankly. If you want to know why I enjoy reading court documents, because these are the voices I hear in my head. Now I'm sharing them with you. Fortunately or unfortunately, yeah. This is accurate. All right. Mr. Gottlieb, Your Honor, I'd like to start, if I could, with a discussion about the appropriate standard of review because I think it cuts across all of UMG's arguments in this case, and it is important to have a reminder, both from the federal standard and the state standard, of why we're here today. Under binding Second Circuit authority, the Global Networks communication case that we cite in our papers, a complaint may not be dismissed pursuant to Rule 12 unless it appears beyond doubt, even when the complaint is liberally construed, that the plaintiff can prove no set of facts in support of his claim which would entitle him to relief. Davis v. Boheim is the only opinion doctrine case cited by either of the parties in this case that remotely touches on the appropriate standard of review at the pleading context for evaluating an opinion defense. And it is utterly devastating to UMG's entire argument in this case. As we explain on pages 1 and 7 of our brief, the question on a Rule 12 motion, whether considering an opinion doctrine defense, is not what this court thinks or what Mr. Ransom thinks a reasonable listener should have concluded when it heard the lyrics in question. The question is whether a reasonable listener could have concluded that the statements were conveying facts about the plaintiff. That the statements, I'm sorry. Oh, I'm going to read that section over because I fumbled it and now I'm getting interrupted. Unfucking believable. Sorry. Deal with that later. Okay. When considering an opinion doctrine defense, it is not what this court thinks or what Mr. Ransom thinks a reasonable listener should have concluded when it heard the lyrics in question. The question is whether a reasonable listener could have concluded that the statements were conveying facts about the plaintiff. Davis v. Boheim is the controlling authority. There's no other case that either party cited that even purports to interpret the standard at the pleading stage. At page 268 of the opinion, the Davis court explained that at the pleading stage, we limit our inquiry to the legal sufficiency of plaintiff's claim without evaluating the sufficiency of the party's evidence, as would happen at the summary judgment phase. Davis expressly argued in this case that the court should reject the plaintiff's interpretation that were contained in the allegations in the complaint and instead hold, using the objective standard, which we don't dispute applies, that the reasonable reader would be likely to interpret this statement as pure opinion. The court rejects that, and this is the most important part of the opinion. The court says, on a motion to dismiss, we consider whether any reading of the complaint supports the defamation claim. Thus, although it may well be that the challenged statements are subject to defendant's interpretation, the motion to dismiss must be denied if the communication at issue, taking the words in the ordinary meaning and context, is also susceptible to a defamatory connotation. Meaning, if it's susceptible to a connotation that it's fact, and it's susceptible to a connotation that it's opinion, the plaintiff wins at the motion to dismiss stage. Judge, I asked Mr. Ransom earlier, though, how do I square that with other Court of Appeals decisions, including Bryan, which was also a motion to dismiss decision, in which they do not purport to overrule, so therefore remains good law, still cited by New York courts, but did not use this could standard, did not say is susceptible to a defamatory connotation, but says instead, the question is whether or not it would be understood by a listener as opinion or fact, and presents it as a question of law. Mr. Gottlieb, so Your Honor, Judge, I take you that Davis definitely throws a wrench in the argument, but there seems to be some tension. How do I reconcile the tension? Mr. Gottlieb, Your Honor, I don't think there's tension. First of all, Davis is the subsequent and most recent opinion, so it would be controlling for this purpose. The Bryan court doesn't purport to interpret the pleading standard, so there was no dispute between the parties as to what the court's inquiry ought to be in evaluating the pleadings on one point. The second is there's no discussion or suggestion in the Bryan opinion anywhere that there was a challenge to the actual content of the allegations in the complaint, which is what we had in Davis. And it is what we have here, where you have the defendants essentially saying, don't credit or believe or draw inferences from the allegations in the complaint in the plaintiff's favor. Instead, accept this other evidence that we're presenting to you and draw inferences in order to determine what the appropriate social context is so you can make your decision as a matter of law. In Bryan, the only thing that the court considers, at least from what one can tell from reading the opinion, is the four corners of the op-ed that was being considered. The court was merely analyzing an op-ed and talking generally about what op-eds are. There's no suggestion in Bryan that there was an attempt to insert intrinsic evidence into the record. There's no suggestion that there was any challenge to the inferences that the plaintiff was being asked to draw of the complaint. And in Bryan, and the Bryan court makes clear that in the context of the article itself, the author made clear that the purpose of the article was to advocate for an independent investigation, and in support of the argument, the defendant marshaled all of the relevant materials, including within the text of the article. So the court had basically everything it needed in order to analyze both whether it was capable of a defamatory meaning, whether it can be proven true or false, and what the context immediately of the article in the broader social context were. There is simply no indication that there was any dispute before the court as to any of that. In this case, we have, by contrast, is an express request for judicial notice that I want to address before I get into the sufficiency of our allegations, if I could. That request for judicial notice asks the court to accept 17 exhibits into the record and to use evidence contained in the exhibits to draw inferences that directly attack, contradict, or undermine the allegations in Drake's complaint. Now, there is a time and place for the weighing of evidence, but that is either at trial or the Rule 56 stage. It's not here. And UMG has no answer whatsoever to the binding Second Circuit authority that we cite at page 14 of our brief, which is the Global Network Communications case, in which the Second Circuit makes clear that the conversion requirement of Rule 12 is mandatory, not discretionary. And under that rule, Judge, Rule 201 allows me to take judicial notice at any stage of the proceeding. That's explicit in the rule. And certainly, ample cases take judicial notice in the context of a motion to dismiss. That doesn't convert it to a summary judgment motion. By definition, it doesn't, because I am permitted to consider both materials within the four corners of the complaint, matters that are incorporated by reference or that are integral to the complaint, and facts that are judicially noticed through Rule 201. And if I do, then that doesn't convert it to a summary judgment motion. Mr. Gottlieb, that's correct, Your Honor. We don't dispute that. What we dispute is UMG's suggestion that the court can either use the materials for either the truth of the matter asserted, which they're disclaiming here, but also can use the materials to make factual inferences based on the content of what the court finds within those exhibits. Judge, well, let's just talk about the song lyrics in the rap battle. There's an argument that they're already incorporated by reference, except perhaps one, the tailor-made freestyle, which was notably omitted in the amended complaint by reference. Remember when the judge said, I want you to redline your changes from your original complaint to your amended complaint so that I don't have to figure out what it is that you changed in your lawsuit? Judge, well, let's just talk about the song lyrics in the rap battle. There's an argument that they're already incorporated by reference, except perhaps one, the tailor-made freestyle, which was notably omitted in the amended complaint by reference. But the other songs in the rap battle are referenced and linked to their Spotify, or I think it was their Spotify listing. So I'm not even sure that I need to take judicial reference that they're not. So I'm not sure that I need to take judicial reference that they're not incorporated by reference in the complaint, but certainly there can't be dispute about what the lyrics are. The lyrics are what they are, Mr. Gottlieb. So to make this easy, we don't challenge that the court can take notice of the fact that lyrics exist in a song out in the world. The question is how one interprets those lyrics and what meaning is given to those lyrics in the context of evaluating the rap battle. Similarly, of course, we don't challenge that there was a rap battle. We plead that in our complaint. Barely, motherfucker, barely. We plead that in our complaint. What we take issue with is UMG using lyrics to draw inferences about what reasonable listeners and reasonable viewers would have understood about the song in question. That is where the argument strays from what is permissible under the court's judicial notice authority, and it also strays, Judge. Once the lyrics are in evidence, then, of course, I can draw inferences from them. They're in evidence. They've been judicially noticed. The lyrics exist. They have the meaning that they have. They're words. And I don't understand your argument that I could take judicial notice of a song lyric, but I'm not allowed to consider what the lyric means or says, Mr. Gottlieb, because at the pleading stage, the court is not allowed to make inferences against the plaintiff. The court is required to draw all reasonable factual inferences in plaintiff's favor, and the court's not allowed to take materials from outside of the complaint and use it to discredit or undermine or question the allegations that have been plausibly alleged in the complaint. And I think this argument around context is an important example. So, for example, we have alleged throughout the complaint what the appropriate context for the understanding of the lyrics, the cover art, the video, and the song are. We have alleged that the full context includes the lyrics of the song, the cover art, and the video, and we have explained in numerous allegations throughout why a reasonable listener or reader or observer would have interpreted those songs as conveying a singular and precise factual message that Drake, and false message that Drake is a pedophile. Judge. But isn't that a legal argument that I don't have to draw an inference in your favor? Because whether a reasonable listener would have drawn that inference is a question of law. What you've already agreed is a question of law. And legal assertions or arguments made in a pleading do not have to be credited by the court. Mr. Gottlieb, the question, though, is not what a reasonable listener would have interpreted the lyrics to mean. The question is whether a reasonable listener could have interpreted the lyrics to mean. In other words, is it reasonably susceptible to a defamatory connotation? That's the Davis standard. And we think that we have more than adequately alleged that. But more to the point, we have specific factual allegations in the complaint that UMG engaged in a coordinated, covert, and unlawful scheme to remove Not Like Us from the rap subgenre. This is new. But more to the point, we have a specific factual allegation in the complaint that UMG engaged in a coordinated, covert, and unlawful scheme to remove Not Like Us from the rap subgenre and turn it into a de facto national anthem. I just got to say, Mr. Gottlieb, that's racist as shit. That's alleged in paragraph 10 and 11 and 128 through 202 of our complaint. The complaint alleges facts showing that UMG wanted to and succeeded in making the song culturally ubiquitous. And this means that the audience, to answer one of the court's questions to my friend, the audience by which to evaluate defamatory meaning in this case is not the people who would be dialed into every back and forth between Kendrick Lamar and Drake in the rap battle, but the audience is everyone exposed to the lyrics and imagery, not just those sort of there in the moment. We cite the Lindell v. Mail Media case in the Second Circuit of Appeals that stands for that proposition. This is particularly important because we also allege with specific numbers that this song achieved a cultural ubiquity unlike any other hip hop song in history. Not just unlike the other songs in the rap battle, but unlike any other song in history. More than 9 billion streams at the time of the filing of our last brief have been 9 billion times have been streamed on this song. Every other track in this rap battle pales in comparison to that. So the relevant audience member, if the court is trying to understand the objective listener, objective viewer, cannot be the person who listened to every single track in the rap battle. That relevant person is probably your average 13-year-old who's alleged to be dancing to the song at a bar mitzvah, who may not have heard any of these other songs before, or may not even be that much of a rap fan. Judge, what would be a very interesting bar mitzvah? Oh, Judge, that would be a very interesting bar mitzvah that played that song. Mr. Gottlieb, that is apparently very popular at bar mitzvahs, Your Honor. Judge, I'll take your word for it. Mr. Gottlieb. There's a separate set of factual allegations in the complaint that add to this that UMG also doesn't add, and that's contained at paragraphs 90 through 92 of the complaint. We allege that in sort of the modern social media environment, allegations of pedophilia are of the far more relevant social context. And whatever might have been true when Judge Daniels was considering these issues in Terrain, today, given the massive global audience for this song, that it reached the entire world. And the social media environment in which allegations of pedophilia land today, audiences are simultaneously primed to believe and primed to react with outrage to allegations of harming children. And that is a direct response to many of the generalizations contained in the cases that UMG cites and many of the arguments they're making. These are specific allegations at paragraph 90 to 92 of our complaint. UMG is asking you, based on their sort of own spin of exhibits, to disregard these well-pleaded factual allegations in the complaint about how sort of the world today received these types of allegations, And we just don't think that can possibly be appropriate at the motion to dismiss phase. Judge, let me go back, because we were addressing the various inferences that can be drawn from the lyrics. And one question I have for you is, do I have to draw an inference from the lyrics? Don't they speak plainly? So, for example, let's go back to the tailor-made freestyle lyric, which is, talk about him liking young girls. That's a gift from me. And in the context with the AI voice of Tupac, one can clearly read it to be a goad from Drake to Kendrick as part of their back and forth in the rap battle to bring up rumors regarding pedophilia and Drake. I don't know how else one could logically read that. If you have an alternate reading, I'd like to hear it. But I don't think I have to draw an extreme inference to understand what that line is. Mr. Gottlieb, well, Your Honor, Judge, what would be the inference that would be favorable to plaintiff of that line other than the one that I've just put forward? Mr. Gottlieb, because, Your Honor, you would have to consider, as Mr. Ransom says, black letter law and opinion doctrine. You don't slice out a single line or a single statement from a song in order to ascertain its meaning. You consider the entire song and the entire lyrics in context. Judge, but I'm asking you about this line in this song. How would I read it? You said I can't draw inferences from these song lyrics. I can just consider their existence. But do I have to draw an inference? Mr. Gottlieb, yes, you judge. The words are the words. Talk about him liking young girls. How else would I read that? Mr. Gottlieb, Your Honor, I don't understand what legal relevance that has to the question of how a reasonable audience member would have understood the lyrics in Not Like Us. Before you even get to talking about the lyrics in his prior song, you would have to come to the conclusion that your average listener to Not Like Us came into the song with that lyric in mind, had heard that song, had been exposed to it, had understood the lyric in the same way that Your Honor is reading them. And there's simply no basis on which to make that determination at the pleading stage in this case. They may come forward with evidence, Judge. Let me have you pause there. I understand that a lot of these cases arise in a very traditional context of a newspaper article or an op-ed or a single communication. But here we have songs that are in communication with each other, a dialogue with one another. One artist releases a song. A few hours later, another song is released that responds to that song, and back and forth. That is the context in which these lyrics arise. So to take Not Like Us as the specific example and just to isolate it, isn't that taking it out of the broader context in which it existed? It would almost be like taking a single paragraph out of an op-ed and not looking at the headline and the remainder of the article, because you can't look at Not Like Us in isolation. It's a response to what came before. Mr. Gottlieb. So, Your Honor, we're not advocating for the court to not consider the context that this song was the penultimate track in a rap battle. That's not our argument. Our argument is that this song in particular, both in this rap battle and in the history of music, is different. It is different in ubiquity it achieved. So its audience was different. It was different in the fact that it was immediately understood in the allegations of our complaint to contain a precise factual allegation and a single factual allegation, the false allegation that Drake is a pedophile. We allege, Judge, at the time Kendrick Lamar released this song, there was no ubiquity. And there was, obviously, he's not a fortune teller. He wasn't going to understand that at the moment he released this song, it was going to have 8-9 billion streams and he would be singing it at the Super Bowl. He was releasing it as part of this back and forth that occurred over a matter of days. And isn't that the context in which I need to understand the assertions made? Not 6 months later that millions and billions of people have now listened to it and may not have that understanding, but at the time the statement was made, it was in direct response. And let me give you a hypothetical. If two people are arguing on the street and throwing insults back and forth, and then later one of them says, okay, that particular statement was slander. You've defamed me. I'd have to know what the interchange between those two individuals were that were throwing insults to understand the full context in which whatever statement was made. Isn't that comparable here? Someone insults. The other person responds with further insults. The other person responds with other insults. How can I just take one of these songs in isolation and apply it and apply a completely different standard to it? Because 3 months later, billions of people have now listened to it. Mr. Gottlieb, Your Honor, I appreciate the question. I think it stems from a lack of grappling with, and perhaps due to imprecise briefing on our part, the role that republication plays in this case. We have alleged in our complaint, I believe in 11 separate paragraphs in the amended complaint, that UMG was responsible for republication of the defamatory material. That's paragraphs 13, 21, 120, 121, 157, 191, 192, 232, 241, 246, and 266. The standard for republication is that a defamatory statement is republished whenever it is intended to and actually reaches a new audience. That's the New York Court of Appeals decision in Firth v. State. We allege this throughout our complaint. UMG said nothing about it until their reply brief in this case. So we have alleged that UMG took steps at multiple times post-May to republish the material and introduce it to new audiences. And each time it did that, it was liable for that republication. And each time it did that, its knowledge at that point in time becomes relevant. And we have pleaded that knowledge in that complaint, including that it knew in July, that it knew in August, based on retraction demand letters that we sent to it, what it knew when it launched the Grammys campaign, what it knew when it launched the Super Bowl campaign. But even if you don't agree with us on that, we allege in the complaint before you get to republication that the defamatory material includes the song, the cover art, both of which were released on May 4, and the video. And the video was not released until July, 2 months after the release of the song. And UMG's knowledge at the time that it released the video, including all of the information that we have alleged in the complaint, including the attack on Drake's home in Toronto, 3 separate attacks on his home in Toronto, the attack on his OVO business in London, the fact that users all over the United States were commenting on him being a pedophile, and the fact that Drake had denied factually the allegations in the Heart Part 6. We make all of those allegations in the complaint about UMG's knowledge at the time of the publication of the video. So that's the latest point. That's the earliest or the latest. But their knowledge clearly at the July point in time, before you even start talking about liability for republication, comes into play. And then, Your Honor, with respect to your question before about sort of removing the song from the factual context of the battle, and doesn't it sort of have to be understood that way? We have alleged that this song was actually understood a sort of singular entity. We allege that this song was actually understood as a sort of singular entity because of its cultural ubiquity. And even the exhibits that UMG has put into its request for judicial notice, they proved this. So for example, UMG has Exhibit P, which is a podcast transcript that we cite a piece of in the amended complaint. Page 4 of that podcast transcript, there is a discussion about how Kendrick is making allegations about Drake. Quote, some of these things have been fact-checked, end quote. And then later down, one of the commenters says, quote, I don't know if there's ever been a time when a rap superstar or 2 rap superstars are contemporaries and one is accusing the other of pedophilia, like in the loudest possible way, end quote. And it continues, quote, contemporaries, people who are making their record label billions of dollars, right? That doesn't usually happen. And this level of allegation, maybe it should inspire some sort of investigation, end quote. Later on page 5, it says that one of the commentators says, quote, it's unclear right now if the claims of Kendrick Lamar's domestic abuse are true, but let's talk more about these allegations around Drake. No one has previously called out Drake in this way. Now it's being raised to a more mainstream conversation because it's a hit that Kendrick is making, end quote. Your Honor, Exhibit B to UMG's request for judicial notice, page 10. The commentators describe Kendrick Lamar in this song as, quote, indicting Drake for years, indicting Drake for years of rumors and speculation, end quote. Indicting, meaning a specific factual charge being made in a song based on rumors and speculation. Notably, Not Like Us doesn't include the rumors and speculation in it. It doesn't talk about any of the underlying rumors that Mr. Ransom was talking about that Drake allegedly had to deal with in his past. It only includes the indictment, the specific charge that he is a certified pedophile. The cover art, which is his actual Toronto home, which, by the way, is also validated by the other exhibit that UMG wants you to take notice of, Exhibit J. Page 4 describes the content of the song as sex offense allegation throughout Not Like Us. Kendrick accuses Drake of having inappropriate sexual relationships with minors. This is also a topic Drake has had to debunk in the past. However, Kendrick doesn't shy away from blowing up the rumors surrounding Drake's personal life with his lyrics, end quote. Later down, the predator accusations include the cover art for the track. In fact, an aerial picture of Drake's mansion, allegedly dotted with sex offender location tags. These are their exhibits from commentators interpreting the lyrics of the song contemporaneously, understanding it with a precise meaning that can be fact-checked, that can be proven true or false. So if these things are in the record, we're fine with it because they all prove that there is a susceptible connotation that can be drawn that the song had precise meaning. Your Honor, I don't know if the court judge. Let me ask you this, though. Your client also, in the course of this rap battle, leveled accusations against Mr. Lamar as well, that he's not the biological father of his child, that he beats his girlfriend. Are those fact or opinion? Mr. Gottlieb, are those, I'm sorry, Your Honor? Judge, are they fact or opinion, those lyrics? Mr. Gottlieb, I don't know that the court has a record sufficient to be able to make that determination because the court doesn't have the context behind all of the different allegations in the song. There isn't a complaint with 250 allegations giving meaning to the lyrics. We don't, was there cover art? We don't know. Was there a video? We don't know. Was there a singular message? We don't know how people understood it. So that is both a determination that the court doesn't need to make, nor is there one that the court has a record to make here. I'm going to read it for you again, because a lot of you are like, he said this, what about that? Well, what do they say about this? This is what they say. They are arguing this in a court of law in front of a fucking judge. This is their legal rationale for how to dismiss Tailor-Made or anything else that Drake said. And can they do it? Abso-fucking-lutely can they can. Is it rooted in law? Yes. They're not just standing there being willfully obtuse. They are masterfully wielding the specificity of the legal argument. Your Honor, I don't know if the court judge. Let me ask you this, though. Your client also, in the course of this rap battle, leveled accusations against Mr. Lamar as well, that he's not the biological father of his child, that he beats his girlfriend. Are those facts or opinion, Mr. Gottlieb? I'm sorry, Your Honor, the court. Are they fact or opinion, those lyrics, Mr. Gottlieb? I don't know that the court has a record sufficient to be able to make the determination because the court doesn't have the context behind all the different allegations in the song. There isn't a complaint with 250 allegations giving meaning to the lyrics. We don't know. Was there cover art? We don't know. Was there a video? We don't know. Was there a singular message? We don't know how people understood it. So that is both a determination that the court doesn't need to make here, nor is there one that the court has a record to make here. That could be the subject of questions that I imagine UMG will want to get into in discovery in this case, but it is certainly not a reason to find that the pleadings fail to state a claim on which relief can be granted. Well, actually, motherfucker, you're the ones who got into it into discovery. You're the one asking about another man's kids. But that's an aside. I don't know if the court wants me to address the actual malice arguments that have been made. The judge, I don't need to hear arguments on actual malice. Mr. Gottlieb, okay, judge. If you would like to briefly address the other two causes of action in the complaint, however, and now I'm going to skim. Excuse me. Baby, we did that in like 90 minutes. We're on page 43 of 53. I'm skimming his arguments on harassment in the second degree and payola. I'm not gonna read this section probably, just so we're clear. I'm gonna get to it's not particularly, it's not in the tone of what we just read. It's very much clarification. And they didn't get into an argument on civil harassment. We rest on our papers and the authorities cited therein unless the court has questions for me. Judge, that would be great. Thank you. Mr. Ransom, I'll give you a brief period for rebuttal. We're back to UMG's lawyers. Y'all make that goal. Shout out to everybody who's watching. Hit that like button. Okay, so let me give myself a second here. I need to turn some air on too. Mr. Ransom. Thank you very much, Your Honor. I will endeavor to be brief. I'm sure you will hold me to it. Let me start, if I could, with Exhibits B, J, and P to our request for judicial notice. Those, again, are articles that are cited in Drake's complaint. And if I heard Mr. Gottlieb correctly, after discussing them, he said these things in the record. Quote, if the court wants to consider them, end quote. I think this is a quote. Quote, we're fine with it, end quote. So I believe that addresses in large part one of the court's first questions as to whether and how it can consider these materials that have been submitted. I believe he said the same as to the song lyrics. When I look, for example, at Exhibit P, and I think about Mr. Gottlieb's characterization of it, I think it also resonates with the court's comments that if the court has these materials in front of it, it can look at them and can look at the entirety of them. So Mr. Gottlieb invoked in Exhibit P the statement, quote, and some of these things have been fact-checked, end quote, suggesting that tended to convey a finding of fact versus opinion that judge. Page 4 of Exhibit P, Mr. Ransom. This is page 4 of Exhibit P, and he quoted solely the portion that some of these things have been fact-checked. He failed to read the rest. This illustrates why context is so important. It says, quote, and some of these things have been fact-checked, like Baka Not Nice, who's a rapper in Drake's crew who was convicted of assaulting a young woman and who was accused of running a prostitution ring, end quote. That's the fact-checked reference. He also overlooks the fact that this article, which they're fine with the court considering in talking about Drake and in talking about the references in Not Like Us, says things like, these are the speaker's quote, we all know the stories of him going to girls' basketball games, and it's in our faces. Let's talk more about these allegations, end quote. That's on page 4 and 5, Your Honor. Quote, let's talk more about these allegations around Drake. Taraka, as you mentioned, there are some things we've seen and heard over the years, end quote. And then it refers to the discussion or the history with Millie Bobby Brown and her relationship with Drake when she was 13 and he was 30 or 31. So these articles provide the context that the court can and should consider in our motion to dismiss. So true with respect to the lyrics. And again, the court asked the question about tailor-made freestyle. And you're right. It is conspicuous that tailor-made freestyle is not included in the footnote in Drake's complaint. But it is referenced in these articles that Drake is fine with the court considering it. And there's no real question that it's part of the battle. And again, I think it speaks to the question of context. Because yes, I focus on the line. Talk about him liking young girls. That's a gift from me, from Drake. But the context of that is not even limited to that line. And Your Honor, I'm going to read it verbatim. Please excuse the profanity. This is the entirety of the statement from Drake. Kendrick, we need ya. The West Coast savior. Engraving your name in some hip hop history. If you deal with this viciously, you seem a little nervous about all the publicity. Fuck this Canadian light skin, Dot. We need a no debating West Coast victory, man. Call him a bitch for me. Talk about him liking young girls. That's a gift from me. End quote. That's the context in which Not Like Us appears. That's the background. That's the history. And that's what clearly conveys this rhetorical hyperbole. That's what you hear in these rap battles is trash talking in the extreme and is not and should not be treated as statements of fact. Very briefly, Your Honor, Mr. Gottlieb says there's no indication of a dispute in Bryan as to the context or connotation of the statements. Bryan is a New York Court of Appeals decision. I'm pretty confident there was a dispute in Bryan. And if the court looks at it, the court reflects that the parties vigorously disputed all issues, but that context was key and that the motion to dismiss was properly granted. Mr. Gottlieb also invokes Global Networks, which is in their brief, albeit not for the point that he cites, and with good reason. On the pleading standard, motion to dismiss standard, Global Networks was effectively overruled by Twombly and Iqbal. So it doesn't actually state the correct standard. Very briefly on the Section 349 claim, I think what the discussion with counsel illustrates is the fundamentally indirect nature of any inquiry or harm that Drake claims, New York business law. It requires consumers doing a thing, Spotify doing a thing, royalty streams doing a thing, multiple steps. And that is not what 349 is intended for. It is not intended to permit any person who claims, in this case, as Drake does, that they were effectively indirectly impacted by some purported consumer deception to bring a claim. That would, frankly, flood and overwhelm the courts in a way that is unsupported by the Court of Appeals requirement that the injury be both tangible, non-speculative, and direct. Judge, thank you very much, Mr. Ransom. Unless the court has questions, I will rest. Judge, thank you very much, counsel, for your arguments today. They were very helpful. The court is going to request that the parties order the transcript and split the cost among them. I'm going to reserve decision on the motion to dismiss, so an opinion will ultimately follow. Are there any other issues that the court needs to take up today? Mr. Gottlieb, none for plaintiff, Your Honor. Mr. Ransom, no, Your Honor. Judge, thank you very much. The court is adjourned. We did it. We did it, gang. We did it. Okay. So once again, for anybody who thinks, oh, the judge just needs to read this and decide it is ridiculous and then throw it out, you are not on the level where this fight that will impact rap is actually happening. I refer you again to today's article on the Post tab. You cannot read that transcript and say with any certainty whatsoever how the judge is going to rule. You cannot, because you do not know. Because she gave nothing away. She showed nothing. She reasonably challenged the arguments of both sides, pointed out the flaws and strengths and arguments on both sides, and pointed out where some shit appeared to be ludicrous on its face. But that doesn't mean that it doesn't have a legal argument to back it up. And that's what she's looking for them to present. Give me your best shot. Take your best at bat. I should not consider tailor-made freestyle. You better give me your best shot as to why. On case law, I don't consider that song. Literally. I don't need to infer anything from the lyrics. They're quite literal. She said words are words. They mean what they mean. I don't have to infer shit. But you're telling me that I should not consider them? And you saw what Drake's lawyers did. They gave her back a legal argument as to why it's irrelevant at this stage. So people who are like, he said it first, and what about when he said and da-da-da-da-da, or he's just going to say he didn't say it and it was actually Tupac, which is childish. Funny, but childish. Not anything that would hold up in court. There's your answer. These lawyers are just fleecing Drake. You don't know what you're talking about, dog. Way above your pay scale. I'm not a lawyer, but if the judge doesn't dismiss this, no lawyer would say that shit, because that's not how it works. This is how it works. Argue your case law and your rationale. They revised it out on purpose, to be sure. And we noticed it at the time when we went through the amended complaint. We noticed a couple things that got shifted around. And I knew that the judge was a smart cookie at the point that she said, when you amend your complaint, redline it. I want to see every word that you change from your original lawsuit to your amended complaint. And she clearly noticed, y'all took out tailor-made freestyle. Interesting. So we did it. we have our first official transcript reading under our belts. We've got this one on the record. If anybody has any informed, intelligent questions, okay? Don't ask me biscuit head ass questions. I am not going to answer them or entertain nonsense. Don't be reductive. Don't oversimplify shit. Let things stand on the complicated nature that they stand on. I am happy to do my best to attempt to answer your question. Okay, but I got to run real quick. I'm not leaving. I just got to grab a package before somebody steals it. Okay. All right. I'll be right back. Oh, that's totally fine. That's totally fine. That's totally fine. I'm totally fine. Yeah, text me. I'll be around. Okay, just text me. Okay, all right. See ya. Child, I opened the front door to grab a package and my elderly neighbor was standing there, and you cannot make eye contact with your elderly neighbor and then not exchange words with them. You have to do your pleasantries and the whatnots. Had to do the pleasantries and the whatnots. Good job. The stream has been going for 1 hour and 54 minutes, and we went through basically the entire transcript of the oral arguments for the motion to dismiss that happened back on June 30th. I doubt it. I doubt it. I'm scrolling. Somebody's asking me about discovery and what they're objecting to. I covered 2 motions to compel in a video live a couple days ago, so you'll have to refer to that because that's actively in motion. Coyote Munson question: does tailor-made freestyle have to be within the documents in order to wholly considered by the court? The court just can't randomly consider whatever it wants to. It has to be something that's entered by the parties itself. That's why I say, for people who are like, the judge is going to be like, I saw what happened, this is bullshit. That's bias. There's a difference between the reality that we lived and saw and the reality and the narrative that is on the court record. So yes, it has to be submitted by a party, and it has to be argued successfully that the judge, it's within the judge's purview to consider it. So whether it's in reference in his document or it comes in through judicial notice. These things have already happened. I just read the document. It's already happened. There is no, so UMG is gonna, it already happened months ago. These things happened months ago. Keep that in mind. This isn't present time. These things happened months ago. It's already been argued in front of the judge. I literally just read it. They did not put it in their exhibits. They put it in their motion for judicial notice. It's a separate thing. This was June 30th. It takes a while. There's a specific process that transcripts go through before they are released to the public. So they are not released right away. So this already happened. The judge has already seen the lyrics because they were already submitted to her. The argument was, can she consider them? Why or why not? That's one of the things that they were arguing over. So there is no submit something new on the motion to dismiss. It's done. They've already submitted everything on paper, and then the last step is your oral argument. So they can't just come up with something else and say, this is for motion to dismiss. It's in the judge's hands. We've been waiting for over 45 days for the decision. So there is no, he's going to amend the lawsuit. Can't do that. Judge already told him that in writing. You get one amendment. He already did that. That's what they argued the motion to dismiss on. So he doesn't get to amend it again. It's done. This is old. We just got the transcript. We read it. But we're way past that. This is not true. This is an oversimplification of what it is that they asked for. And people need to stop doing that. So, no, I didn't see that. I read that document. I read all of Drake's discovery production requests here live. And that's not what he asked for. No, there are several stages in between now and an actual trial. Again, that's an oversimplification. There are other means by which this case does not proceed to trial in its current form. There are too many things. There are too many factors because there are things that haven't even happened yet. The case is in discovery. Okay. So there are many, many stages of a case before it actually gets to trial. And then there's a stage after trial when everything's been decided. So this is why I say when people are like, he's going to win the motion to dismiss, and that means he's going to win the case, or he won the right to serve a witness. He didn't win shit. He filed a routine motion that is as routine could be. It's not something that the other party objects to and they get into court and they fight about it. It's routine. They asked permission to do something and the judge said yes. That doesn't mean that the judge isn't going to dismiss all or part of the case. That doesn't mean that the judge believes Drake and doesn't believe UMG. All of those kinds of simplifications come from people who want to reduce the process into something quick and simple, but they take it out of the reality of what it actually is. Yeah, well, therein lies the problem. Therein lies the problem. And, you know, over the past 48 hours, I've had people on lives in the replay gang come into the comment section and say, I heard this thing on TikTok, or I read this article and it says da 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 about what's in a court document that I read. I'm supposed to believe that over what's in the actual court document. People are trying to give you summary sound bites so that you will pay them by clicking on their shit. If you want to understand what's in the motion to dismiss, guess what? It takes 2 hours to read it. Not a soundbite on TikTok. It's quite annoying because people come to me like, I don't know what the fuck I'm talking about. They ain't read a goddamn court document. Not a one. Let's get through these super chats. Okay, Sharp, again, thank you. I appreciate you very much. Rooney, thank you for the $10 contribution. I hope I helped some hours at work tick by a little bit faster. You know, hope you were entertained. Demi, thank you for the $5 contribution to the document fund. Super sticker from Rice Cake, $10. Thank you very much. Super sticker from Raphael, $10. Thank you, beautiful. Ariel Smoke, $2. Love and respect for the work you do, Abseth. Thank you, dollar. T-Mac, $20 super sticker. Appreciate you. Queen Medina with the 5 on it. Saloina with the 5 on it. Demetrius with the 5 on it. Kim Briggs with the 5 on it. Y'all came through. Ekins? Ekinse? Sheesh for the reading. I was exhausted with the back and forth. Child, it is a lot. I'm hot. Definitely hot. I started off this feeling cold. Like, I need a sweater. I went and changed. Because I was like, I'm going to get cold and shivery. No, I'm hot now. Spooky Ariel, thank you. Thank you. Tamia, hey, beautiful. Thank you for the $5 contribution. Moni, 1984. Monet, super sticker. Thank you. Tiffany Shante coming through. Hey, beautiful. Good to see you. The Reign of Oswin. Thank you, beautiful. For Anomaly. I love that. I love that. That's witty. Thank you for the $2 contribution. Curry Goats. Thank you. Thank you. I find it incredibly ironic that this dropped and the Canadian hip hop coverage has magically taken the day off. Anti-Black media outlets are quiet. Yeah, well, you know. KGK, thank you for the $4 contribution. Replay Gang, Abscess Live, Voice Protection T Fund. Oh, I appreciate you. I appreciate you. For Anomaly, another 5. In his own filings, he says that plays are bought, so I guess K-Dot has real listeners now. I guess so. Which is it? The flip-flopping of Gottlieb in this around context was hilarious to me. And I know I was going pretty fast and not stopping to like give a bunch of commentary, but he flip-flopped so hard a couple times on context. Just what's my argument in the moment right now that's going to help me the most was funny to see. But yeah. The Drock 08, thank you for the $10 contribution. Dropping by to pay those tithes. Yeah, we're all a little sick of his ass. W. Graham Boulevard, thank you for the $5 contribution. Michelle Johnston. So this is why they asked for those records. Well, I covered that in another live. Easy, thank you. Doing the Lord's work. I'm sure, I'll take that. I think that's a little lofty, but why not? For the goal, thank you. Stout Shaco. Have a token of my appreciation as I go run it back so I can get caught up. Thank you for the $10 contribution. I said it earlier, but I think I got it wrong. Lord knows I can't be an attorney. I'm going to be screaming, preposterous. I mean, that could be a good argument. Ekinze, 1877. Thank you for the contribution. James Mariel Ellison. The motherfuckers don't have no friends. Really, no friends. No friends. No friends. No friends. Pua Helani, Docket Fund. Thank you, beautiful. I saw that I'm pretty sure that you tried to pledge on rhetorical question. I'm not going to monetize that. But if you want to pledge on the other Substack, if it's your jam, you can. Or you can become a member. Well, you are a member. I mean, Docket Fund is good. I just wanted to let you know you should not actually get a charge or anything like that, because I'm not going to monetize that. So hopefully it didn't charge you anything. I didn't give it in my information to take your money. And I didn't realize it was set up to even accept pledges until a couple of them rolled in. It took me a minute to figure out how to turn that off. So my bad. But thank you. I appreciate the thought. T-Mac with another super sticker. Thank you, beautiful. Salient. Hey, beautiful. No comment to offer. Just a little support for all the work that you do. Thank you. Because I'm so hungry right now. Mods, send that Cash App around. I ate right before this live so that I could have my, my protein, and carbs just like fresh, and they're gone. They are gone. My brain is like, where'd the fuel go? Burned through all of it. Lady Samira, thank you for the $20 contribution. Amazing reading, Absa. Team Ronson, but also Drake's lawyer did his job. What was your take on Judge Vargas and her lack of interest in NLU stream numbers in context of considering the motion? Love how direct she is. I mean, most judges are. I think that I one of the things that I know that she demonstrated is that she is up on the case, that she has read absolutely everything that has been submitted. She's intimately familiar with the details of the arguments to the extent that she can point out holes in them in a really, really precise way. And that's encouraging. You want that from any judge. I trust, because I know that this is about impartiality and not about Drake's going to win or Drake's going to lose. I trust that she's going to make the most legally accurate ruling on motion to dismiss that she can make. That doesn't mean I'm going to like it. But I trust that she's going to do that. So people, the judges, but you simp ass motherfuckers. Come on. Josie, 78, thank you for the contribution. Thank you so much for reading this document for us and explaining court jargon that most of us do not understand. You're welcome. I love your platform. Thank you. Here's a little something towards the doc fund. Appreciate you. Old school Gemini. Thank you, Absa. Thank you, beautiful. Eric, hello, beautiful. Thank you for the $5 contribution. Killing it as always. I'm trying, beloved. I'm trying. DMV doll. Thank you for the $10 super sticker. Ooh, A Brown. Gifted 5 abso-fucking-lutely memberships. I appreciate you, beautiful. Carolyn, thank you for the contribution. And Demetrius. What's your take on the part when Gottlieb said they removed NLU from the rap subgenre and turned it into a de facto national anthem? Oh, beloved, I said it before, and I'll happily, with my whole chest, say it again. I think that shit is racist as fuck. Yeah. Yeah. And it's par for the course for the little dog whistles that he has slipped into his motions on behalf of Drake. It's also factually not true, because if you go to any platform and look at the genre or subgenre that Not Like Us is under, we all know where the fuck it is. And there's no such goddamn thing as a de facto national anthem. And even if there is, what's wrong with it being Not Like Us? Rhetorical question for the lawyer who likes to dog whistle. $72 having fun. Thank you so much for that contribution. I appreciate you. Is there anything that you find notably absent from the arguments on either side? Whew. My answer today is no. I just read this with you all, so my brain is going to be back there in the background chewing on it for a while, and I may have some, it would have been nice if, oh man, I wish they would have. But I agree with their consistent hammering of context. I think that is key argument number one for their position, is the context in which everything happened and what Drake did. And I think that they've always pretty masterfully, just like they're like, well, according to Drake's own lawsuit, like those kinds of arguments, I love that shit. Because I feel, that Drake's lawyers were forced to concede. And I think upon reading and reflecting on Drake's arguments, I think some are, and this is my armchair stance, I think that there are some that they appear to be really fucking solid and confident on. And then there are others that, again, they flip-flopped on. And I'm sure she noticed that in the moment. And I'm sure she's noticing that, in her review of the transcript as she writes her decision. That doesn't mean it has a material impact on ultimately what her decision is. Because the only thing that she's deciding right now, the things that she is deciding right now are very narrow and really they're complicated, but on the face, very simple, straightforward things. When you get under them, those things are each very complicated. But I agree that context is fucking key. I say that all the time. I think that was the most important thing that they had to pin down, and I think they did a very good job of when she gave them appropriate pushback on their arguments that they had others. Unless a judge directly tells you don't say that shit again, which they're not likely to do if you're making a legal argument. When a judge gives you pushback, you come back to the same argument, but from a different angle and with something else to back it up. And both sides did that. But Drake's lawyers specifically did flip-flop on some shit. So that's my take today. They included it as a part of their original complaint, and then they amended it out. They amended it out of their amended complaint. I don't know. It depends on if somebody buys me dinner. We'll see. I have no idea. I'm just hungry and I'm amazed that my brain burned through all that shit as fast as it did. Yeah, it was. Lady Samira says, I did not appreciate that tidbit about de facto national anthem. It was a huge microaggression. Yeah, it's a dog whistle. To imply that a rap song could not be so ubiquitous is insulting. It's fucking insulting. It's also reductive and an oversimplification to define rap, the history of rap in the way that he did without proper context. Because we are not living in the same times as when Fight the Power dropped. Everything is different. How music is shared, experienced, is different. So to flatten it down to this static thing of like the history of rap is only one thing ever, and no other song ever achieves this level of anything. Well, there are some that just didn't fucking qualify because we didn't have streaming. You know? No, I didn't read it that way at all. I didn't read it I definitely did not read that Drake's lawyers were getting snipey with the judge at all. The judge was asking reasonable, legally rhetorical questions. And judges are not above reproach when you meet them with a solid legal argument that they haven't themselves thought of, or you put a legal argument in relevant context that they hadn't considered before. So it's common for judges to be like, isn't this 1 + 1 = 2? And then it's up to the judges to argue, no, actually, this is complex math. Let me explain how. And let me explain based on previous cases and case law and decisions why. So like I said, in that respect, it's unremarkable in oral arguments on a motion to dismiss. This is typical. It's only remarkable because we're actually reading about a fucking rap diss. We've got lawyers who are paid thousands of dollars who are standing up in court fighting over what one man said, what it meant, what it didn't mean, how it should be considered, how it should be interpreted, in what context it should or should not be considered. Because the Canadian is fucking butthurt that he lost, like a bitch he lost, like a hoe he lost. Motherfucker lost. Did I mention he lost? That bitch boy lost.
I study rap battles for a living.
Hello, Anubis D. Wicked. It's good to see you, beautiful. Couple of bucks. For a living, he lost. Yeah. Red Lotus Diva. I feel like you're saying he lost. I mean, does lost mean what we think? I don't know. Is there a music video? Was there a visual to it? I don't know. Does lost mean lost? That shit was, whoo, Lord. When you witness what lawyers stand up and say with their whole face, it's really fascinating. And for them to be like, the meaning and impact of tailor-made freestyle, Your Honor, we just simply don't have enough information. And you don't need to worry yourself with that. The court does not need to worry its pretty little head with tailor-made freestyle. Oh, yeah, that was great. What did it mean? We don't know. Was there a visual? We don't know. Judge said, words are words. Thank you, beautiful. I appreciate that. I'm not going to get this for another month and a half, though. Mod, send around them links. Right. What? Tailor-made who? That was funny. That was one of the funniest points when the judge said, so are these lyrics truth or fact? He said, huh? Oh God, that was funny. That was funny. He said, huh? I'm sorry, Your Honor, what? How could you not anticipate that you were going to be asked that question? You should have anticipated that the judge was going to ask you that question. So these lyrics right here, buddy, what do these mean? Huh? What lyrics? And they literally said, we're not saying you can't acknowledge the fact that lyrics exist there out in the world. We're just saying you can't infer anything from those lyrics. She said, do I need to? Do I need to interpret the lyrics? Seems pretty fucking, oh my God. Wow, Simply Beautiful 9021. That's a big old contribution. I think that's the biggest contribution that we have received on this channel. Wow. Thank you. I appreciate you. Mods, send her out my cash.
High five. I'm bulletproof.
This is beautiful. Thank you very much. I really do appreciate that. I really do. I appreciate every contribution. It $2, $1.99. Melvin, Dolores, Tamiko, Jason, I see you. Tia, I see you. I see you up in my emails. Thank you. Child, it's all going back into that docket fund at the end of the day. No. Raphael says, I like the hypothetical question posed by the judge. Two parties arguing with each other and decide a month later to sue for defamation. Judge would need to get the back and forth of what was said. And also, why now versus when it was actually said? That was another, I thought that was another great question. Why now? Why now versus when? And she said, Kenny don't have a crystal ball. He didn't know he didn't know it was going to be ubiquitous. He didn't know he was going to be performing it at the Super Bowl. Shouldn't I be considering it then versus 3 months later when your client is upset because so many billions of people heard it? That's not a direct quote, but it's a hard, it's a hard reference to what she said. Your client got upset months later and was like, I need to sue. Wasn't a problem until white people started saying, well, actually, we don't want to hear Drake say nigga no more. That's because I told you where I keep it. You're slick. down in Dixie said, let me get close to the bosom. Thank you, beautiful. Can be a one. Huh? What? He's such a bitch. Oh, God, he's such a bitch. But we did it. We know what was said. We know what the arguments were. Because now it's a de facto national anthem. Ooh. He's supposed to be America's favorite. It's supposed to be him. It's not supposed to be anybody else but him. Such a bitch. I don't give a fuck about who you hang with. The chatter. If this does get dismissed soon, would that precedent help to make it more difficult to abuse the legal system around diss tracks going forward? So a couple things. Well, one thing. People should anticipate, regardless of what the decision is for the motion to dismiss, that it will be appealed. Tammy, thank you for the support. It doesn't matter what it is. Whichever side loses the motion to dismiss, they're going to appeal. And then it will go to the Second Circuit Court of Appeals, and they'll rule on it fucking probably next year. Shit. Jesus. So case law won't really be decided on this case. Well, I mean, case law will automatically result from whatever the judge's decision is, but the ultimate implications of it won't be decided until after an appeal. So I can't answer your question to that level of specificity, except to say that the outcome is going to set a legal standard. That legal standard won't be clarified until after the appeal of the decision of the motion to dismiss. There's no way. This is a prediction I'm comfortable laying out. There's no way the losing side doesn't file a motion to appeal or doesn't file for an appeal. That was funny. That was funny. It was definitely a worthy read, you know. It was definitely a worthy read. And I hope it was really informative. It really it doesn't matter if you understood all the words. It doesn't matter if you knew the intricacies of the case law. There's so much bullshit out there on the internet about what this case is about what litigation is, about what judges do, about what is evidence, about what was actually said in discovery and what the fuck wasn't said in discovery. All of these things. And boy, does it grind my gears when somebody tells me, oh, I was just watching somebody who said, I'm not a lawyer, but if the judge doesn't dismiss this case, everybody on the internet looking at her sideways. She doesn't watch YouTube. She doesn't give a fuck. That's not her standard for anything. And nobody who is actually a lawyer would fix their fucking mouth to say that. Why is anybody listening to your ass? This is actually what a motion to dismiss is about. This is reality. Not the TikTok sound bites, not the people pushing their opinion of what should be done about a process they know nothing about. It's on Court Listener. You don't need to get into it. The people here already paid for it, so now it's just available. That's my give back. They don't even read a fucking document. They watch this channel so that I read it to them and explain it to them, or they go and they pick one section, they take it out of context and just run with it, ignore everything else, so that they can appear smart and confident to their audience, whilst encouraging them not to know the facts and not to think too fucking hard. This is it exactly. I don't care what's said on the internet. I care about what's in the documents on the docket. And the only reason I wrote today's article is because people bring me this shit. I've addressed the things that I addressed in the article at least 30 times in videos or in lives. Now there's one article. It's short, sweet, and to the fucking point. Every time these things happen, people bring up this reductive reasoning around this case. That link is going to be my response. I've never debated with people. I'm not about to start now. It's a gift. Many people do. Good job, everybody. Good job. If you're in the right position, it is. It is. If you're in the wrong position, it is not. But y'all are in the right position, so you're good to go. With my whole chest, beloved. With my whole chest. Reason and stupid don't sit at the same table. I'm not debating dumb motherfuckers over facts. Because they want content. No. Since you asked so nicely, yes, I can. Another little something for pronouncing hyperbole the other way by mistake. I said it 2 times and it wasn't by mistake. I was showing my dexterity, throwing off the ones who are going to be like, she said it wrong. Oh, wait, she said it right. What does that mean? It means get over yourself, beloved. That's what it means. But I said it both ways on purpose. Lots of new eyeballs. There were a lot of people in the live, which is surprising to me, and they stayed for the majority of the reading of it. And the fact that there were so many people in the live tells me that there was probably a lot of new people. So I made the choice to say it both ways for those people. You're welcome, beautiful. I think you was just trying to get to my coin purse again. I'm not mad at you. Like I said, you got strategy. Hey, good to see you. Diaz, thank you for the $10 contribution. Says, your reading was, chef's kiss. I think this judge tested them both. It's really hard to know which way she leans. Yeah. I think she leads into whatever she interprets to be the most sound case law, because no judge likes to be turned over on appeal. They want to get it right. You know, they want to get it right. And so they're going to write a decision that they feel like is going to hold up against an appeal. And it is legally the right decision to make. It doesn't matter how they fucking feel. It's what is per the law within my purview and based on case law, which is then it is prescribed to me what I am to do in this case. It is prescribed to me what I am to do in this case. It's not just willy-nilly off of my opinion. So I think that's the way that she's leaning. I don't want to be overturned on an appeal. Where judges have ego, it's typically there. Let me get it right. Let me get it right the first time. So the Court of Appeals backs me up when it goes there, because this one's going to go there. K-Way, hey, beautiful. Thank you for the $10 contribution. Peace and thank you, Absa. You helped me get through this hike. Hey, love it. You hit the nail on the head regarding the appeal. I hope that boy is saving his money because this can get costly. Well, he ain't saving his money, but he's prepared to pay. So here we are. Yeah, here we are. Yeah, because the other thing is you look like a fucking dumbass. You are running around the grocery store with apples in your hand, waving them in everybody's face, telling them they're oranges. You look like a dumbass. I don't care if you run around looking like a dumbass. I'm not going to debate you. I'm not going to try and convince you of a fucking fact. This is willful stupidity and willful ignorance. Not my monkey, not my show. Have fun with that. Alicia, thank you for your support. But also, don't bring it to me if you watch that content. Don't bring it to me and fix your fingers to tell me in my comment section that I'm wrong because you saw a biscuit head say a thing and they don't have a fucking primary document to cite. Like a transcript. Like a court filing. You're asking me to be willfully stupid, and I'm not going to do that. Thank you, beautiful. Y'all did the damn thing. Simply beautiful. I struggle to see how UMG might settle because won't that potentially invite more lawsuits in the future? Well, it might not be UMG's decision. UMG has an insurance company, and the insurance company has lawyers. And they're as much a part of this case and what does and doesn't happen as anybody. And any case can get to a point where the insurance company steps in and says, you need to try and settle this case. Having said that, they are not discussing settlement. And I'm going to assert that as an absolute fucking fact because I read it on the docket. Drake will not even entertain the possibility of a discussion of a settlement until he has Kendrick Lamar's fully unredacted contract. So it's not even at issue here at this stage, no matter what you hear on the internet. But a great question. And do not ask me or promote the foolish bullshit that some other YouTuber said and then ask me to comment on it. Go read the article from today and assume that it applies to all the bullshit. Don't mention those people's names. If they are putting trash out onto the internet, definitely don't come over here and sully this channel's integrity or ask me to comment on it because I don't watch trash. Even when you bring me things and tell me about things that are happening, I don't then immediately go and watch it. 9 times out of 10, I don't watch it. I protect my algo. I don't need to know the specificity of the dumb fuckery going on over there. I'm not the YouTube police. It's not my job to check people and fact check people on stupidity, especially when they've decided they'd rather collect a coin than pay for a fucking fact. So don't do that here. I will quite literally never, because I don't give a fuck. You are more than welcome to go off and be stupid. It doesn't lessen facts or actual intelligence. I didn't say that. Okie dokie. Would they have to trust Drake's word that he'd drop the case if he gets the contract? Or could they put that into writing first? I didn't say that. I can only respond to what it is that I actually said. So that's another thing that I've been dealing with over the past 48 hours is people intentionally or otherwise taking my words out of context, either to push their own narrative or because they weren't listening to the nuance of what I actually said. What I actually said was Drake will not even entertain the idea of a conversation about settlement until he sees Kendrick Lamar's contract. That is not reflected in your reductive regurgitation of what I said. I am Shishi. Thank you for the contribution, beautiful. I appreciate you. He's getting it. They've been in discovery for months, and now they're fighting over what is going to be shared. We're just at the beginning of that fight. We don't know how long it's going to go on. Discovery technically is calendared through the beginning of 2026. So that's why I always say we're in the first 5 minutes of this case. When people are like, oh my God, are we there yet? And trust me, I go through that too. But when people are like, why is this dragging out so long? This isn't dragging out. This is typical. This is typical how the actual court process works, not what you see on television and Judge Judy. So nothing's getting dragged out. This is how it goes. This is how it goes. So he's getting discovery, and now they're arguing over things UMG doesn't want to hand over. And I would imagine as soon as next week that we will see that they are also arguing over things that Drake doesn't want to hand over. But that is also typical and unremarkable. It's only remarkable for us because of the topic, because of the things. But in the case of it being a lawsuit and there being discovery and people wanting this and the other, standard. It's standard, basic, typical, routine, even. Welcome, beautiful. It's good to have you. Hit the like button, hit the subscribe button, turn your notifications on. I do my best to never waste your time. That's the assumption that people should make, and I've said that from the beginning. I can be incredulous and disgusted and have my own personal opinion about him being a bitch-ass motherfucker, and then also understand the process. So that's been my position for a while, is people should not assume this case is going to get dismissed. Nobody can say with any certainty whatsoever that it is. I have my own for funsies little predictions, but they're just that. For funsies in my own head, little predictions. But I will not be surprised if this case is not thrown out in part or in its entirety. I won't be surprised if it is. I'll have an emotional reaction either way. and then I'll read the ruling or read the order, read the decision to understand specifically the legal reason why. That's it. And whether I agree with it or not is completely fucking irrelevant, because who the fuck am I in this arena? I'm not a party, not an authority, and my opinion doesn't matter. And neither does anybody else's. Yes, there was a ruling on discovery does not get stayed, and a bunch of people said, see, Drake is winning. See, the judge believes him. No, the judge went to case law and established precedent and said, as a matter of law, what is dictated to me already on the books that the courts have already decided, discovery goes forward. That's the reality of how the process works. So Drake J. Sixers trying to twist everything into, see, he won. That shit is just immature noise. It has no bearing on anything whatsoever and doesn't make delusion fact. Baby, this list is too long. Nisha Falk 28. What would you ask for in discovery from Drake? This is too long. This list is too long. In Drake's, might add that to the list. In Drake's first round of discovery requests to UMG, he had 18 things. In UMG's first round of discovery requests to Drake, they had 138. That's my style. I feel comforted by that. Yeah. I could easily come up with 200 first round questions for Drake of documentation that I want. Easily. But that would take a lot of fucking work because I would be serious about it. We tried this before on the channel months ago when we read the first round of discovery requests. We tried to compile a list and I started taking people's suggestions like, what do you want to know? What do I want to know? And I realized there's no way for me to actually put this list together without being extremely fucking thorough, like categorizing it and subcategorizing it. It would have taken me hours upon hours upon hours. And I was like, I'm not being paid for this. So I let it go. But I could easily come up with 200 relevant questions for Drake, relevant to his claims in his lawsuit of discovery requests for documents. And that doesn't even get into interrogatories. And interrogatories are written questions that he would have to answer. So, yeah, I had to let it go. I'm not quick enough to make it either. I thought about it too, because I did see Jake in my head, but I was like, I'm not, my brain is too fried after reading that thing to formulate any original thought. They have not. UMG has not filed any. You don't usually publicly see discovery details. Because these are things that the lawyers work in good faith behind closed doors to argue about and work out amongst themselves. It only comes onto a court docket when they cannot agree, and therefore one party files a motion to compel against the other party. Drake's lawyers filed 2 motions to compel earlier this week. We had a live covering both of them. So in doing so, to back up their motion, they attached the document requests that they have been giving to UMG, at least some of them. We saw 1 through 3. There could be 4, 5, 6. We don't know. But we saw 1 through 3 comprised of a total of 79 questions for document production. We have not seen UMG's 138, but if Drake doesn't give them everything in that 138, UMG will file a motion to compel. They will attach that shit to be demonstrative to the court, and then we'll be able to read it. And we will. Oh, baby, we will. Oh, baby, we will. No, that's not necessarily true. I just clarified that. Well, I'm glad you enjoyed it. I hope you have a good rest of your night. So that's that on that. Any other pressing questions on this before we call it a night and I go faint on the couch? It was, like I said, it will, I mean, you never know what's going to be in a thing until you read it. So yeah, I'd have to agree. It was pretty good. It was pretty good. I'm going to go work something out, child. Okay, so there is another cat. We're calling him Ghost because I haven't seen him yet. But my neighbors swear to me that he comes into the patio. It's an all-white cat. Or maybe I have, and because where the camera is positioned, I mistook him for Oscar because I can only see like where the camera is right now. I can only see legs down, basically. And this cat only comes at night, according to my neighbors. And then, so it's night vision. Everything that shows up on the fucking camera that moves is white. So I just realized this morning, like, oh snap, maybe I have seen the cat and I haven't realized it. I'm gonna have to move the camera. I haven't done that yet. But yes, just based off of what my neighbors have said, there's another cat. We're calling him Ghost because he's white. And because I don't think I've seen him yet. But yeah. Me too. Me too. The Drock 08. Yeah, this case has really opened my eyes to how drawn out these processes are. I almost didn't want to cover it with Skip anymore, but we have to. This case is so important. Yeah, it is. And everyone go read that article. It's really good. Yes, this is specifically what judges deny discovery for, but first they have to argue about it. So they're going to argue about it on paper, and then they may argue about it in oral arguments. So she's not just going to read the motions to compel and rule. They get to do the back and forth on paper. Drake's lawyers have said this is why we need this. Eventually there will be a document filing from UMG saying this is why they fucking don't. Or why it's overbroad, or why it's not directly relevant, and da-da-da-da-da. So, yeah, it's a process. So there's different kinds of testimony, right? Can people get called to court to testify? Yeah. Can people get subpoenaed to be asked questions in a deposition well before a trial? Yeah, they can. If they think that you have relevant material information, then you will get served with a subpoena for a deposition. That's when you have to go in, sit down, and unless you plead the 5th or the 14th or whatever amendment to not answer the questions, you have to answer their questions. If you don't answer their questions, they can file a motion to compel. Same thing. Go to the judge, argue why you have to, you submit why you don't, They respond to why you think you don't. There may be oral arguments or an evidentiary hearing, and then the judge makes a ruling about, no, you do need to answer these particular questions. DJ Ronnie Ron says, thank you so much for giving your time and insight. You're welcome, beautiful. Oh my God. We might need to change the cat's name to Peekaboo. All in favor? All in favor, say aye. We're going to change the cat's name from Ghost to Peekaboo. The motion is seconded. The ayes have it.
I'm bulletproof.
Good job, everybody. Good job. Yep, they sure do. So if you are a YouTuber, you could receive a subpoena. They're not going to subpoena you for your records related to your channel. They're going to subpoena around you. But if they want you to answer questions under oath and under the threat of penalty of perjury, they're going to serve you a subpoena. Now, you can argue with the court that you're not relevant to it, or the court doesn't have jurisdiction over you, or blah, blah, blah. But you can try all those things. Perez Hilton is trying that right now on the Blake Lively docket. Probably going to lose because he's also showing his whole ass to the judge. But you can try and argue, no, I ain't got nothing to do with this, but you need a lawyer to do it. So, yeah, they have to pay for their own counsel. Y'all are out of control. I appreciate you. It was good to hang with you. Make sure you like this on the way out. Leave a comment in the regular comment section and post it somewhere. Sharing is caring, as they say. I hope to see you all soon. Again, have a wonderful, 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 wonderful night. Peace.